Come on, my dear friends, as we are continuing with the new series, that is case studies. So let us let us first of all define what a case study is. So literally we can say that a case study is a detailed study of a specific subject such as a person, group, place, event, organization or phenomenon. Fine. Case studies are commonly used in social, educational, clinical and business research. Fine. But we focus more we focus more on the aspects, facts, issues, decisions taken, etc. etc. when the two parties, or we can say when two parties are opposing each other on some conflicts in the world of patents. Fine. So let us dig a little deeper by going into some specific cases. Fine? Okay. Wow. So, with this beautiful figure, let us proceed with the detailed one. Fine? So, friends, now is the turn for case study number 5. And this is about Renon Health Care Pvt Limited versus UOI and others. Okay, so let us continue. So, first of all, we will go through the facts. Okay, a patent owned by Kibo Biotech Incorporation, which is a dietary supplement that aids in the functioning of the kidney, had a writ petition filed against it, which was rejected by the Madras High Court due to a lack of expert evidence to support the case. Okay, so the thing is that Kibo Biotech Incorporation, it was owning a patent. Okay, what is that patent about? This is about a dietary supplement that aids in the functioning of the kidney. Fine. And here what happens, it had a writ petition filed against it. Okay, that means it had a, we can say, this particular company had a writ petition filed against it, which was rejected by the Madras High Court. That means someone has filed a writ petition against this company. Okay, and this was rejected by the Madras High Court. What is the reason? The reason is due to a lack of expert evidence to support the case. Fine. This is very brief description of this particular case. Okay, let us proceed with some more facts. In the writ petition, the validity of the patent was challenged under Section 3, Clause E of the Patents Act, stating that it was a substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substance. Fine. So, in the writ petition, validity of the patent was challenged actually. And this is as per Section 3, Clause E. And friends, we know that Section 3, Clause E is about a substance obtained by a mere admixture, okay, resulting only in the aggregation of the properties of the components thereof or a process for producing such substances. So, please refer Section 3, Clause E for the same. Fine. So, we can proceed now, okay. Now, what is the issue? The issue is, we can say, what are the shortcomings of the patent revocation attempt in light of failing to substantiate its case by submitting expert evidence in support of its claims? So, this is the issue. Fine. Okay, let us proceed. Now we will see how the court took the decision. Okay, stepwise we can see. The Madras High Court laid much emphasis on the importance of expert advice in the technicalities of matters, as reliance could not be placed merely on the documents and arguments. This is fine, because without an expert's advice only based on the documents and arguments, a decision cannot be made. Fine. For instance, looking to the conclusion made by the IPAB, that is Intellectual Property Appellate Board, that the patent by Kibo Biotech provides aid to kidney functioning. Fine. For example, or for instance, we can say, looking to the conclusion made by the IPAB that the patent by Kibo Biotech provides aid to kidney functioning. Fine. Now, the court held that such a finding could not have been given without the help of a scientific advisor and or technical expert's evidence. Okay. So, the court said that the IPAB could only have held that the materials filed by the petitioner were not sufficient to revoke the patent. That means the court said that the IPAB could only have held what it could have. That means we can say the court said that the IPAB could only have held that the materials filed by the petitioner, okay, were not sufficient. That means only the materials that were filed by the petitioner is not sufficient for the revocation of a patent. Okay. Hence, to this extent, the observations made by the IPAB in its order were liable to be expunged. Okay. And we know that the meaning of literal meaning of expunged it to remove completely. That means we can say the observations made by the IPAB in its order were liable to be expunged or completely removed. Fine. Now let us proceed. Now the court has surmised that the burden of proof when a patent is challenged lay on the person making the challenge. Okay. When a patent is challenged, then the burden of proof lies on the person who challenges it. Fine. Hence, why the writ was eventually thrown out and the patent grant remained held to be valid. Hence, we can say the writ was eventually thrown out and the patent grant remained held to be valid. Okay, so we can say in a way that the conclusion is the writ was eventually thrown out and the patent grant remained held to be valid. Okay, so the decision is like this. Fine. Okay, now the court noted that the scope of the writ petition was limited to whether there was any infirmity in the procedure adopted by the IPAB while deciding the revocation application. Okay. The scope of the writ petition was analyzed and it was seen that it was limited. Okay. Now the second point is, or the next point is, while holding that there was no such infirmity, the court also noted that the order against revocation could not be found to be erroneous due to errors on the face of the record. Listen it carefully, friends. While holding that there was no such infirmity, the court also noted that the order against revocation could not be termed to be erroneous due to errors on the face of the record. That means, basing on the documents only, a decision cannot be taken. Fine. Now, a noteworthy plausible outcome of this court order is that it might promote increasing academic involvement in patent litigation. So, what is a very good outcome of this type of decisions is that it might promote increasing academic involvement in patent litigations. Okay. So, it will encourage the academic involvement in the patent litigations. Fine. So, friends, this way we could finalize the whereabouts of this case study, what are the facts, what was the issue, what decisions were taken, and how gradually the decisions were taken. All of these things are discussed here. So please go through each and every slide of this video lecture, and if you are getting stuck anywhere, please write them down in the comment box. Okay friends, happy learning. So friends, enrich your brain cell with proper food and proper knowledge. So thank you all my dear friends for listening to me and watching my video. Please like, share and subscribe my channel. Please keep questioning, please keep learning and keep enjoying. Thank you so much. God bless you. Jai Hind.